empowered in 2002 to give effect in Australian law to international law dealing with war crimes. Not only has no one ever been charged, they refused to even countenance a discussion on it. And when it was raised by Senator Di Natale in the Senate, there was much faux outrage that he should even question the actions of Australian military personnel. Di Natale said there is much that needs to be answered, and the only proper way is to have a proper inquiry. Bombings of wedding parties and hospitals, all of which have occurred in Afghanistan, Iraq and Syria, are war crimes. The bombings of cities during World War II are another illustration. The destruction of Hamburg, where incendiary bombs were used, and the majority of people killed were killed because all of the oxygen in the air was sucked out by the intensity of the flames caused by the incendiary bombs. The bombing of Dresden, which was a hospital city and was pure revenge for the German bombing of Coventry, are particularly egregious examples and were undoubtedly war crimes. We won that war, or at least the Russians won it for us. The last war we actually won, thanks to Russia and China, who carried the brunt of the fighting and the overwhelming mass of the casualties against Germany and Japan, respectively. 26 million Russians died in that war. More Russians died at the Battle of Stalingrad than the entire Allied forces combined for the whole war. Between 20 and 25 million Chinese died fighting the Japanese. But because we won, people like Churchill were never put on trial. More recent examples are not hard to find, including, as I've already mentioned, the American/Australian-led assault on Fallujah in October-November 2004, and more recently in Mosul in 2017. I mention in particular those two examples because Australian military personnel were heavily involved. Now, as I've already mentioned, in the case of Fallujah, an Australian general, now a senator, was actually the commanding officer. The use of military force, whether it is bombing, drones, naval operations, land forces, etc., must necessarily be resorted to only in compliance with international law. One of the most important principles here, because virtually every state in the world is a party to it, is the United Nations Charter. And Article 51 of that Charter provides for, in limited circumstances, the right of a country to defend itself. But it doesn't exist in isolation. Before that article can be invoked, it must be in compliance with other provisions of the Charter. For example, Article 2, which provides in subsection 3 that all members shall settle their disputes by peaceful means. And further provides, subsection 4, that all members shall refrain from the threat or use of force against the territorial independence of any state. Cast your mind back to the rather childish but dangerous and juvenile threats by our joined-at-the-hip ally in the White House against North Korea. The statements and actions of the United States in particular and its allies over the past 72 years make a mockery of those provisions. As John Menadue has recently pointed out in Pearls and Irritationals on the 8th of February, Since 1776, the United States has been at war for 93% of the time. Out of 248 armed conflicts since 1945, 201 of those, that's 4 out of every 5, have been initiated by the United States. If force is resorted to, and of this obviously includes the use of drones, then that force must be in compliance with Article 51 of the Charter and the body of international law that has been developed in the post-World War II period interpreting the Charter's provisions. Article 51 provides a right to collective self-defence if an armed attack is made against a member state. There are important caveats to that right, both in the Charter and in international law. For example, force may only be used until such times as the United Nations Security Council has taken measures to maintain international peace and security. There is a further requirement that the need to use force must be necessary and that it is urgent. Further, the use of the force must be proportionate to the initiating incident. Now, as is well known, the ostensible reason for the attack on Afghanistan were the events of 11th of September 2001. We now know, however, that the decision to invade Afghanistan was made in July 2001. It is impossible, in my view, to argue that even if the official reason for the attack on Afghanistan in October 2001 was true, that you could sustain that argument by occupying that country, still being there, still causing untold havoc more than 16 years later. The use of force may be justified under the self-defence provisions of the Charter if a request is made for assistance by the country which is itself attacked. The Australian government, in respect of its involvement in the Syrian war, has misrepresented this provision. Foreign Minister Julie Bishop was interviewed on ABC Radio in November of 2015, the day after an article of mine appeared in New Matilda, pointing out the illegality of our involvement in that Syrian war. And she was asked what was the legal basis for Australia being there. And she said, "We are there at the request of the Iraqi government and pursuant to the collective self-defence provisions of Article 51 of the UN Charter." This naturally rolls off one's tongue when one is interviewed on ABC Radio. The collective self-defence provision upon which Bishop said the Australian government relied is only applicable when a state is attacked by another state. The various terrorist groups operating in Iraq and Syria under US, Saudi, UK and Israeli sponsorship are not a state in any legal sense. Also inconvenient for Ms. Bishop was that a few days after she made the statement in the interview, the Iraqi Prime Minister's office issued a statement saying, "Actually, we've made no such request." That was not reported in the Australian media. The Syrian government has repeatedly made clear that the presence of US and quote-unquote coalition forces, including Australia, in or over Syrian territory is unwelcome and is in breach of international law. Our government, always so ready to pronounce its support for what it is pleased to call a rules-based international order, simply ignores the Syrian protests. The use of force may be authorised by the United Nations Security Council. This has not happened in the case of Afghanistan, Iraq and Syria. There is, in my view, a very strong argument that Australia's involvement in all those wars is illegal under international law. The same is true of Australia's involvement in the earlier Vietnam War. In an international law context, use of drones is not inherently unlawful. As with the use of any other weapons, the lawfulness is determined by the circumstances in which they are deployed. In other words, the use must be within the context of either force that is authorised by the United Nations Security Council or in self-defence. I would argue that the use of drones for the purpose of targeting individuals, groups or infrastructure in Afghanistan, Iraq and Syria, I use those three examples because Australia is a participant in each of those wars, is illegal under international law. Whether they are used in the course of committing war crimes, when they are used, in the course of committing war crimes, of which there is abundant evidence, then those participating are guilty of war crimes. Which brings me back to Pine Gap. As I noted earlier, Pine Gap is an essential component of worldwide guidance systems for military purposes. This includes the guidance of missiles and drones to their targets. Australia, by this involvement, is therefore a party to the commission of war crimes when those missiles and drones are used in such a way as to fall foul of the relevant provisions of international law. This, and I'm sorry to be repeating myself, again, is never discussed in our mainstream media. It is a dialogue that is long overdue. Thank you.